The Mitakshara Hindu joint family is one of the most important concepts of Hindu law. Derived from the commentary Mitakshara written by Vijayaneshwara on the Yajnavalkya Smriti. The Mitakshara school governs inheritance and property rights among Hindus in most parts of India, excluding West Bengal and Assam where the Dayabhaga system applies. To understand, it is essential to distinguish between the joint family and the coparcenary concept of Mitakshara Hindu joint family. HJF. A Hindu joint family is a family arrangement under Hindu law consisting of all persons lineally descended from a common ancestor, and includes their wives, widows, unmarried daughters, adopted children, living together and bound by a common relationship. Property and worship. Rights to property are acquired by birth. Under this system, property is owned jointly by members of the family, and rights in the property arise by birth. Foundation. It is a creature of law, not contract. You are born into it. Continuity. It does not perish with the death of the common ancestor. It can continue indefinitely as long as there is a common thread of descent. Composition of a Mitakshara joint family. A Mitakshara joint family is broader than a coparcenar. It includes 1. Coparcenars. 2. Non-coparcenars, the members who are not coparcenars. 3. Carta. 4. Joint property. Coparcenars, co-members who acquire interest in joint property by birth. Traditionally, traditional rule, male line, male members up to 4 generations. Son, grandson, great-grandson. Modern rule, inclusion of females. After Hindu succession, Amendment, Act, 2005, daughters are also coparcenars with equal rights. Legal rights. Coparcenars have the right to demand a partition of the joint family property. They have a right to be maintained out of the joint funds. And upon their death, their share is subject to the rule of survivorship. Non-coparcenars, members, who are not coparcenars, their wives or widows of coparcenars, mothers and unmarried daughters. Key case, Vinita Sharma, Rakesh Sharma, daughters have equal coparcenary rights by birth. Adopted children, legally adopted members have the same status as biological ones. Legal rights, they have the right to maintenance, but not have the right to demand partition. However, they have an absolute right to be maintained out of the joint family funds. A right to residence, and the right to receive a share when a partition actually takes place among the coparcenars. Carta, the common ancestor. Carta, the common ancestor, usually the senior-most coparcenar of the family is usually the carter. Manager. Carter is the head and manager of the family. Carter can be male or female. After legal developments, Pushpin case, Sajata Sharma v. Manu Gupta, eldest daughter can be Karta. A vital distinction. A joint family can exist even without property, but a coparcenary cannot exist without joint family property. Who can be a member? Membership is acquired mainly by birth in the family, or marriage into it. For wives, outsiders can join only by adoption. The family can continue indefinitely even after the death of the common ancestor, as lower generation males become the new links. Essential features of Mitakshara HJF. Unity of ownership and possession. Property is jointly owned by all coparcenars. No individual has a definite share until partition. Until partition, the interest is fluctuating. It decreases with a birth and increases with a death. Right by birth. Jus sanguinis, Janmaswatvavada. A coparcenar gets rights immediately on birth. This is the most distinctive feature of Mitakshara law. Community of interest and possession. All members have common ownership and enjoy property jointly. No individual co-partner can say, I own exactly 25% until a partition occurs. No need for agreement, creation of law. A joint family is created by status, birth, not contract. No formal agreement is required. The doctrine of survivorship. Earlier, property passed by survivorship, now modified by Hindu Succession Act, 1956 and 2005 amendment. More emphasis on inheritance rights, especially for women. Traditional Mitakshara law followed the rule of survivorship. When a co-partner dies, his interest does not go to his heirs via a will or succession. Instead, it is distributed among the surviving co-partners. Note: the 2005 amendment has largely superseded this. Now, even co-partnery property devolves via testamentary or intestate succession under Section 6 of HSA, though the notional partition remains a tool for calculation. The doctrine of blending. The doctrine of blending is the voluntary act where a co-partner throws their self-acquired property into the common stock of the joint family with the clear intention of abandoning separate claims. Once blended, the property loses its individual character and is treated as joint family property, making it subject to the rights of other co-partners by birth. The Carter manager. The eldest male member is typically the Carter. He has unique powers. Power of alienation. Can sell, mortgage property for apart-kale. Legal necessity. Kutumbarthe. Benefit of the estate. Or pious purposes. Management. He has absolute control over income and expenditure. Presumption of jointness. Under Section 110 of the Indian Evidence Act, law presumes that a Hindu family is joint and their property is joint family property unless proved otherwise. Partition and secession. Any co-partner can generally demand partition. Partition leads to division of property in shares. After partition, each co-partner becomes the absolute owner of his separated share, at least in relation to that property. Fluctuating interest. Share of each co-partner changes with births and deaths in the family. The position of females. Post 2005. Prior to 2005, daughters were members of the HJF but not co-partners. Following the 2005 amendment and the landmark Vinita Sharma v. Rakesh Sharma case, daughters are now co-partners by birth. They have the same rights and liabilities as sons. They can act as Carter of the HJF. Wider than co-partnery. Joint family includes co-partners plus non-co-partners. Hence, it is a broader concept. No separate legal personality. A Mitakshara joint family is a unit of persons, not a corporation or a separate legal entity. It has no legal personality distinct from its members. For legal purposes, contracts, suits, etc., it acts through the Carter or any other member duly authorized. State of Maharashtra v. Narayan Rao Sham Rao Deshmukh, distinction between joint family and co-partnery. Types of property in a joint family. To understand the HJF, one must distinguish between the types of property held. Property type. Description. Ancestral property. Inherited from father, paternal grandfather, or great-grandfather. Interest is acquired by birth. Self-acquired property. Earned through personal exertion, gift, or willow. The family has no claim to this unless it is voluntarily thrown into the common stock. Important case law. Vinita Sharma v. Rakesh Sharma, 2020. The Supreme Court clarified that daughters have co-partnery rights by birth, regardless of whether their father was alive when the 2005 amendment was passed. State Bank of India v. Ghamandi Ram, 1969, defined the Mitakshara JHF as a unique legal entity with no equivalent in English law. Conclusion. The Mitakshara Hindu joint family is a unique legal institution of Hindu law, characterized by unity, joint ownership, and rights by birth, centered on the community of interest, while modern legislation like the Hindu Succession Act has introduced individualistic trends, like the right of daughters and the ability to will away one's interest. The HJF remains the fundamental social unit of Hindu law. The 2005 amendment has finally aligned this ancient system with the constitutional mandate of gender equality,